Let's just think about youth transitioning out of adulthood and the extension of care to foster youth over the age of 18 in many jurisdictions up through age 21. That's protective, right? That's a recognition that foster youth coming out of the system at age 18, and I have 22 and 27-year-old daughters, so for me it was an easy sort of understanding that there's no way my daughters at 18 were able to take care of themselves. But we all knew that, and yet we had this fiction that we could push foster youth out of the system at 18 and they would suddenly magically become mature adults. They're not. They need help, they need our protection. And so we have extended care in many jurisdictions, and I'm sure we will continue to do that for youth aging out of care over the age of 18, but not to delinquent youth. For delinquent youth, we don't extend the jurisdiction of the juvenile court. We don't say that youth who commit crimes at 18, although they're in that same developmental stage and certainly neurologically that same undeveloped stage as their foster youth peers, we don't say that we're going to think about them differently. Instead, we presume an autonomy and autonomous decision-making on their part to engage in criminal conduct. In New York, and I'm sure there are folks here from New York, you can't, in New York, if you are 16 and 17, you're an adult. For any crime that you commit, you are considered to be an adult in the state of New York. We're hopeful that that's going to change within the next year or so, but that has historically been the way that youth have been treated in the New York system with respect to their involvement in the justice system. Treating kids as adults, prosecuting any child as an adult. We treat a 14-year-old as much too young to participate in all kinds of civic activities in society, 15, 16, 17-year-olds, and yet we also are willing to say, if you commit a certain kind of crime, if it's particularly serious, if you use a weapon, suddenly we impose autonomy on you, the ability to make an intentional decision about engaging in that particular contact and conduct. Let's think about sexual conduct between very young children. If you think about how many states penalize and will punish and will charge delinquency in cases of two individuals under the age of 14, under the age of 13, both of them, engaging in some type of sexual contact from the very minimal to perhaps more severe or more serious. Oftentimes what happens is that the prosecutor makes a decision, they charge one is the victim and one is the perpetrator, because that's the way the system is designed to operate. And yet both of those children under the age of 14 or 13 or 12 are in the protected class that we also, as a society, as a state, have made a determination requires our protection. So when we think about this work going forward, the message and the set of questions that I would leave you with is that we are in a very dynamic time. We have a series of Supreme Court decisions that have established a new floor of protection. We don't know where that ceiling is, but we have a new floor of protection that recognizes that the distinctive attributes of adolescence and youth that make them less blameworthy for their criminal conduct require a different response and a different set of interventions. We also have another set of policies unfolding on the child welfare side that are also recognizing that older youth require greater protections. At the same time, all of us in this room, whatever job we hold, we're all advocates for youth. And we all know through our work that the voices of youth must be heard, that youth must have the ability to participate in the critical decisions that affect their lives and to shape their lives and to reflect on the kinds of decisions that we make about them. So the question that I pose to you and that I leave you with is really, under what circumstances, when and where is it appropriate to impose autonomy on youth? And that's what we do when we impose criminal responsibility. Under what circumstances is it appropriate to deny autonomy to youth? Under what circumstances is it appropriate to provide protection to youth, as we are increasingly doing for kids at the most severe end of the criminal justice spectrum, as we are doing for older youth in foster care, but under what circumstances do we allow ourselves to deny protection? And that comes out not just in how we think about even the continued prosecution of youth in the adult system. Harsh circumstances that children find themselves in the justice system, the use of solitary confinement, isolation, restraints, other kinds of harsh practices. This is all this tension between protection on the one hand, autonomy, empowerment, and control. Questions that we have struggled with in different ways, I think, throughout history, but I would argue are questions that we really have a moment now where we need to confront them very directly, and I think we have an opportunity to come up with some different answers. Thank you.